So let's look at the second of our videos on the advantages and disadvantages, the evaluation of lay people in the criminal courts. And this time we're going to focus on jurors. The last one, of course, was on magistrates. And I'll just crack straight on and go straight into it. The first of these advantages are that the jury system presents a balance against state interference. And by that I mean that the jury can return a not guilty verdict without fear of any consequences. And this originally originates from a 1670s case between two men called Penn and Mead, both of whom were Quakers, who decided to riot. And the judge in that case made it very, very clear that he expected the jury to find the defendants guilty, and they didn't. And because he was so enraged by the fact that they hadn't followed what he wanted them to do, he locked all of the jury up. And it was only when they were released on writ of habeas corpus that it was made very, very clear from that point on that juries should be able to make decisions on their own basis without interference from the state. And there's a good modern example of that, and that's in the case of somebody called Clive Ponton. Very famous case. Clive Ponton was a civil servant, and he worked for the MOD. And in 1982, as part of the Falklands conflict, the British Navy sank a Argentinian battleship known as the General Belgrano. Ignore that. So it's the General Belgrano. And there was quite an amazing uproar at the time, because it was alleged that the General Belgrano was not in disputed waters and was shot at whilst it was retreating from the war zone. And Clive Ponton was asked to put together a briefing for Parliament. And he was certain that what Parliament was doing, what the government were doing, was misleading the remainder of Parliament and the public. So Clive Ponton put together or leaked a certain amount of information and sent it to an MP who he knew would be absolutely outraged by the fact that the government was withholding, or appeared to be withholding, information from Parliament. He was caught and prosecuted under the Official Secrets Act. So lots of writing in this Official Secrets Act. And it was very, very clear that what Clive Ponton had done did in fact breach the Official Secrets Act. Yet, nevertheless, he won his case, and the jury refused to free him. The jury refused to convict him, and I suppose in essence that demonstrates that even though it was probably the right and proper thing was to find Clive Ponton guilty, the jury were able to free him without any fear of consequences from the government. And this leads to the second of our advantages, in that very often the jury can deliver what are known as perverse verdicts, and the Pontins case is a good example of this. There's a second example of a perverse verdict, and that's the case of a lady called Cronlid. And it's a case in 1996. In 1996, she and two others decided that they would break into the British Aerospace factory in Warton, which is in Lancashire. And at that time, British Aerospace were making aircraft which they were selling to Indonesia. And the Indonesians at that time were in a dispute with East Timor. And it was alleged that the Indonesians weren't behaving necessarily fairly in East Timor. And Mrs. Cronlid and her associates broke in, and with with domestic hammers, caused a huge amount of damage to an aircraft, a very expensive aircraft. Now, they didn't leave, they didn't run away, they stayed there and staged a protest. They called a publicist from British Aerospace whilst they were there. They were subsequently arrested and charged with £2 million. So £2 million worth of damage. And the court directed very clearly that the criminal damage had been caused by these ladies, and that in effect the evidence that was provided was not in dispute, that nevertheless the jury decided that they would clear Cronlid and her two co-defendants because they decided that what they were doing was right, even though all of the evidence against them made it very, very clear that Mrs. Cronlid was guilty. So the jury can deliver perverse verdicts, those verdicts that perhaps are at odds against all of the evidence that's presented. The third advantage of the jury system is that it is generally racially balanced. In 2007, there was some research conducted, and that research suggested that there was no bias either in the numbers of ethnic minorities that were being called or sitting on juries, and also in outcomes. So even where there were mixed race juries, there were not perverse or biased outcomes in terms of different defendants from different ethnic backgrounds. So it shows that not only is the system balanced in terms of our ethnic minorities, but it also shows that the outcomes are fair. So that's a huge advantage. And finally, we've got this notion of public participation. And we've heard this throughout this unit, in that the concept of jury service serves society. It is this whole point of civic duty. If we can take part in our judicial system, we can keep the judicial system fair, and it feels as if we have a democratic role as individuals. The survey also showed that there was a huge amount of enthusiasm amongst the general public for jury service, with about 2/3 of people that were questioned who were very supportive. Of the 1/3 that weren't supportive of their jury service, this was primarily because of inconvenience, not because they disagreed with the system. The whole point about not being at work and having to create childcare and those sorts of issues. So the public participation enthusiasm is based much more on the system, whereas the anti-league, the people who didn't find it particularly helpful, were doing that on the basis of inconvenience. So those are our four main advantages. The fact that it's a balance against state interference, that sometimes it can give perverse verdicts, that it's racially balanced, and that it engenders public participation. So let's have a quick look then and look at the disadvantages for that. And unfortunately, in much the same way that we can say that jurors can do what they want, at the same time they don't need to give any reasons for their verdicts. And sometimes this has been suggested that it may be that the jury has had enough and it wants to get home. And because of that, what often happens is that the jury will go along with the flow. They will, let's just suggest there's 10 members of the jury that wants to give a guilty verdict and 2 that don't. Rather than fight that, very often it has been suggested that they may very well just go along with the flow in order to get away. And we don't know that because, of course, they don't have to give a reason as to why they've arrived at the verdicts that they have. And the only time that this is found out, really, is when a juror complains. And when a juror complains about activity within the jury system or within the jury room, then automatically we go to a retrial. And it's then that we find out that this sort of issue might have happened. And there's a good example of that. The case of Stephen Young. And Stephen Young was an insurance broker. And in 1994, he was accused of murder, a double murder. And it came to light sometimes afterwards that the jury deliberated by using a Ouija board, of completely and utterly inappropriate. So, of course, Mr. Young was retrialed. Of course, this isn't Mr. Young, this is O.J. Simpson, of course. I've only used this image just to show that the jury in the O.J. Simpson came up with a very bizarre verdict. But yes, Stephen Young was retried, and at his retrial he was still found guilty. But nevertheless, this idea of a Ouija board being used to come to the verdict probably shows that actually it demonstrates quite clearly this notion of there's no need for any reason to be given. Now, I know we've said the second disadvantage is that I'm suggesting that it's not truly representative. And I know that we've said that it's a way of participating in society, and it's a way of and they tend to be 12 members of our peers. But if we look as an extension of the magistrates' court system that we were looking at earlier, I challenge as to whether or not the jury system is truly representative. And let's just think about this. If we look at what we saw last time about disqualifications, all of those people who cannot sit. So criminals form a part of our society, yet they're not allowed to sit on juries. Similarly, so there are lots of people that are, or that are not. So I put eligible when I should have put ineligible, of course. But there are lots of people that are ineligible to sit on jury service, and those people, of course, are then not representative, aren't they? Similarly, so most defendants are under 25. Now, the fact that juries are selected by random means that not the majority of the jury will not be under 25. So the challenge is how truly representative, in terms of a jury of the defendant's peers, are a jury that consists of people that, perhaps are not under 25. And I've put this picture up here just to show that, young mothers are unlikely to sit with the frequency on juries that perhaps others might. And that's because they have childcare issues and may find a reason to demonstrate their either excusal or deferral. And I'm guessing then that means that young mothers aren't representative of the public. So there are a number of groups that would fit into this. But it just gives some idea about the fact that we can actually state that we can challenge the representation on a jury system. Now, the third disadvantage is one that quite frequently crops up, and which is about the lack of ability. And we're talking about knowledge. Most of you guys that are studying law will know how much more you've learnt since we've started than what you knew already. And we're only on the first journey of our academic law study. Can you imagine how complex some of these cases may possibly be, and how difficult they may very well be for juries to understand some of that complexity? There's a particular problem with fraud cases. Fraud cases are very, very complex. And it's now the case that a judge may sit on their own without a jury. So a judge may sit on own without a jury in fraud cases for two reasons. One, because of the complexity of the information that is presented. And secondly, because fraud cases frequently have a criminal gang element to them, or an organised crime element to them, and therefore to prevent jury intimidation, very often judges are allowed to sit on those cases on their own. So there is a challenge as to whether or not the jurors generally have the ability to carry out that work. And finally, the final disadvantage is this notion of the effect of jury service. Whereas most jurors see it as an engaging experience, jury service, as I said, it's a civic duty, and it helps us to be a part of society. The problem is that a number of cases can be very telling on individuals. And if we look at the James Bolger case, or if we look at the Soham murders, some of the information that jurors tend to be given in part of their listening to the evidence can be very, very traumatic and cause them all sorts of problems afterwards. Now, since 2007, there has been a counselling service available to jurors post-trial. But again, we've stated quite clearly that the whole concept of the jury system is that it should be confidential. Jurors aren't allowed to talk about their jury service or their deliberations outside of the deliberation room. And it's very, very difficult then to address counselling issues if you can't talk about the key elements of the things that have affected you quite badly. So there we go. We've looked at 4 clear advantages: this balance against state interference, perverse verdicts, racially balanced and public participation. And we've looked at the disadvantages of a jury system, which shows that there's no need for a reasoned verdict. I would challenge that it's not truly representative of the public. Whether jurors or not have the ability to carry out the job successfully, and the effect that it has on certain members of the jury. So that concludes our look at the criminal court system, and I hope that these short videos in that have been helpful to you.